Okay, we'll go on the record, case 10-20-2571, State versus David Pompa. We're here for sentencing. David State. Thomas for the defense. This is a proceeding open to the public, so it may be live streamed so the public can view that. Thomas, are we ready to go forward to sentencing?
We are, Your Honor.
Mr. Pompa, I guess the first question is, have you had a chance to review the pre-sentence report prepared in this matter?
Yes, Your Honor.
Any questions about any of that?
No, Your Honor.
Is there any reason that you might have not to go forward to sentencing at this time?
No, Your Honor.
Unless any comments on the pre-sentence report?
No, Your Honor, just argument.
Is Bean, any victim impact statements today?
Yes, Your Honor. I've been asked to read this by the victim, Honorable Judge Joel E. Tingey. Your Honor, I am absent today due to medical issues. With your permission, I am asking a member of the court to read my statement. I was given custody of David when he was 29 months old. At that time, I was 60 years old. I was single and working full-time. I had him assessed at the Las Vegas Children's Center in Las Vegas, Nevada, as I was living in Nevada at the time. His diagnosis was, quote, emotional disability, end quote. David has had hundreds of hours of counseling, therapy, teacher's aides, PSRs, and guidance from coaches and leaders in sports, music, and scouting, to name, excuse me, to name just a few. David found interest in the Bible, he found a church, and was baptized. I gave him 12 years of my senior years, and now my last years are lived in fear. I do not go for walks. I am afraid to go anywhere alone. I never sit or stand in a place I cannot put my back to the wall, as I fear someone coming up behind me and stabbing me as David did. I cannot sleep at night because of the flashbacks of that horrible attack. I believe David will always be a threat to his family. David needs to be in a controlled environment and for a long time. He needs to be punished for robbery and attempting to murder in order to take what he wanted. Thank you, the victim. Your Honor, the state would like to add this as a supplement to the pre-sentence investigation. I will let the court know this is a redacted copy pursuant to conversations I had with Mr. Thomas, and these are Mr. Thomas's redactions. But so that's why it looks the way it does. But if I could submit that to the court as an addendum to the PSI.
We have no objection to that.
Very good.
Thank you.
Any comments on victim impact statements, Ms. Bean?
No, Your Honor, just there's additional information I'll talk about in my argument. Thank you.
Let's have your recommendations for sentence.
Thank you, Your Honor. Pursuant to plea agreement, we are going to recommend, I guess we should probably know, I guess the court should probably advise us to whether or not they're going to accept the plea agreement or not, or, okay. So what we're going to do, Your Honor, we're going to ask the court to sentence him to 10 years fixed, 20 years indeterminate. We believe that it's a well thought out plea agreement. justified in many ways, both aggravating and mitigating circumstances. Mr. Pompa did indicate to the pre-sentence investigator that he was high on methamphetamines and alcohol when this event happened. That certainly is not an excuse, but we do believe that it is mitigating in his defense. His LSI is a 37, which is extremely high. However, he does have mental illness. He spent time in State Hospital South as well as in BHC, which we believe contributed to the high LSI and the erratic behavior throughout his lifetime, which caused the high LSI. The relationship between Mr. Pompa and his parents is dysfunctional at best. He indicated that to me and to his PSI writer that there were drugs being used when Mr. Pompa was a young child, possibly before birth, in vitro. There could be some issues there. But at any rate, he was taken away from his parents. His father went to prison and his mother was taken, the custody was taken away. And he was sent to his great-grandmother's house, who raised him for the most part. Their relationship also is strained and has some serious issues. The great-grandmother, the victim here, was physically abusive to both of the children. And I don't say that to disparage the victim, but I believe it's mitigating to my client in that she was put on the child abuse registry. The children were eventually taken out of the home from the victim. So there was some volatility in that relationship as well, which more than likely created this whole mess of dysfunction between Mr. Pompa's role as a child and his parents, grandparents, and great-grandparents as the caregivers of that child. And so there are, I mean, even though these are horrible circumstances and the horrible things that he did, there are some mitigation here. There is some mitigation here. And we believe that the 10-year fixed term gives the state sufficient pound of flesh, if you will, or punishment, but also gives light to the possibility of a life after prison. And I think that's important for Mr. Pompa to know that there is a possibility that he will be reintegrated into society and that he will someday be out there in society, and that he has hope. There is hope there. Among the many mental health issues that he had some cognitive screening results which showed that he had difficulty succeeding at age level verbal knowledge, comprehension tasks, memory tasks, cognitive speediness, auditory processing, cognitive efficiency. He was diagnosed with oppositional defiant disorder at a very young age. He had very elevated aggression and identified as a student with emotional disturbance. You know, I'm not going to say that society failed Mr. Pompa or that Mr. Pompa failed society. This is a very complex situation between Mr. Pompa and his caregivers. But at the end of the day, we know that Mr. Pompa eventually, hopefully, will be reintegrated into society and move on. The PSI writer in her recommendations indicated that those issues that I outlined were some of the things that were pressing and that were giving pause to the recommendation. He indicated that Mr. Pompa did not appear to grasp the seriousness of his behavior. I think which is probably age-related as well as the cognitive and mental health issues that he suffers from. And so it goes on to say that it's been established that he and his great-grandmother have a dysfunctional relationship and mutually abusive relationship. But it doesn't justify his behavior, or nothing would justify behavior of this type. But again, Judge, we would ask that the court go along with the plea agreement based on those mitigating factors. I'm sure that the state's going to outline several of the aggravating factors, but we would agree that there are several mitigating factors. Thank you.
Ms. Bean?
Thank you, Your Honor. Mr. Thomas did talk about some of the mitigating factors in this case, and the state would like to point out a couple more mitigating factors. In this case, the state appreciates that the defendant took accountability for his actions by pleading guilty both to the attempted murder and the robbery charge. In addition to the mental health issues that Mr. Thomas has talked about, which are legitimate and certainly played a part in his actions, both in his prior criminal history and in what happened at this time, he's also a very young man with a long life ahead of him. And we don't like to see young people in front of the court, especially with these types of serious charges. So those are additional mitigating factors in the defendant's behalf. This case is very serious. The nature of the main aggravating factor is just what happened on this day back in March of this year. The victim had gone to a neighbor's house. The neighbor called the police, and the police came, and this is what they found. The victim told the officer that it was David that had hurt her and said he was waiting for her to die. The officer went next door, which was to her house, and saw blood on the stair rails, the front doormat, the front door, in the entryway leading to the living room, on a brown recliner, and there was a significant amount of blood on the floor by the chair. When they talked again to the victim at the hospital, she said that that day David had called her and wanted to go to Eugene, Oregon to visit his dad, who had just been released from prison. She said she would help get him a bus ticket, and he said he was walking towards her house. When he got there, she told him to take a shower. She was watching TV and waiting for him to clean up. She said David came up behind her chair, grabbed her by the forehead and said, quote, "You're going to die, you bitch, just let it happen," end of quote. At first, she thought he had given her a shot, then realized he had plunged a knife into her neck. She walked towards the door, telling him to leave and that she wouldn't tell anyone. He said he wouldn't leave until she was done and he was going to take her pickup. She heard him call a friend and say it was done, but if she didn't die soon, he was going to keep stabbing her. The victim said David took her phone and her purse, which had about $500 in it. When David was in the hallway, she ran out of the house to the neighbor's house. She said David was heading to Eugene to be with his father. When asked to describe the incident, she said after David stabbed her, she waked up from the chair. So I think there's a typo there. She walked from the chair to the door. David stopped her and pushed her down, and she laid against the couch. She heard him saying he would stab her a few more times, so she went limp on the floor so he would think she was dying. When he walked to the end of the hall, she got up and ran, screaming through the front yard. She did not want David anywhere near her, as she felt he was capable of murder and was laughing about it. That's from the official version in the pre-sentence investigation. This is a case where the defendant tried to take away the victim's life just for basically doing her job as an adult and helping hold kids accountable for their actions. He appears to minimize things a little bit in the pre-sentence investigation from what he initially told police about his planning to kill her on his way to her house and doing it to get into the Crips gang. Instead, he is now saying he blacked out. In the PSI, the victim does a great job and a very impactful job of describing the real life effects to being a survivor of attempted murder. We cannot underestimate and minimize the trauma that she went through of being stabbed and then hearing her attacker say she is just supposed to let it happen, meaning she should just let herself be killed. Additionally, she does not just have the physical injuries that she is recovering from. Her entire world has been shaken and altered. The defendant has had numerous opportunities, and the state would submit that society has not failed him. He was committed to the Department of Juvenile Corrections and had time on juvenile probation, all of which are going towards his competency development through the goals of the juvenile system. In addition, the state invests tens of thousands of dollars into children who are committed to the department's care and custody through that process in juvenile court. A juvenile has to demonstrate that they're suitable to be released from that facility and then go out again on a period of monitoring in the community by juvenile probation. I was involved in Mr. Pompa's juvenile case and have been involved in a great detail in the juvenile system. And so take a little bit of issue with society failing him, because I think society has tried. I do believe Mr. Pompa has significant mental health issues that make it more difficult to deal with him than another child or even adult that does not have those complicating factors. But certainly the state has put a great deal of effort into his rehabilitation and treatment. Given all that information, the state is, along with the defense, asking the court to accept the binding provision of the plea agreement for 10 years fixed, 20 years indeterminate, for a total unified sentence of 30 years. The binding plea agreement that was carefully negotiated through the parties makes sense because the court has 4 goals of sentencing. First and foremost is protection of society. And this is someone who has made it known through his actions that the court needs to protect society from this person. He and his associates, and from the police report and in the pre-sentence investigation, it discussed that he was consulting someone and they felt it was better to kill someone else than for him to kill himself. People who are associates that encourage him to inflict harm on others are not people that he should be associating with and that society should also be concerned about. But that was his belief at the time. He was also desirous of escalating his criminal behavior by being involved in a gang. The court needs to look at deterrence for this defendant and for others. And imposing a significant prison sentence followed by a lengthy period of parole type monitoring sends the message to this defendant and to others that this behavior and criminal conduct will not be tolerated. The court should also look to the defendant's rehabilitation, and that rehabilitation will occur in the Idaho Department of Corrections, especially as part of a pre-release portion of his incarceration before a parole setting. IDOC is adequately equipped to provide mental health services to the defendant, and he should take advantage of those while he's in the prison setting. And then the last goal of sentencing is punishment. And the court and the state and even the defendant cannot go back in time and undo what the defendant did to the victim in this case. So there must be a punishment aspect to the vicious attack that he inflicted upon her. And the state would submit to the court that the joint and hopefully binding portion of the plea agreement would take care of all of those goals, including protection of society and punishment. This defendant, as I mentioned, has had numerous opportunities at treatment. And at the end of the day, we have to make society safe. And if that means a prison sentence, which the crime demands, then that's what the court should do. The length of that we would submit is what is in the plea agreement that we're asking the court to go along with. Additionally, Your Honor, the state has submitted a motion for costs and restitution in the amount of $1,924.77. And the state would ask that that be ordered if there's no objection to that amount. Thank you.
Comments on the motion for restitution? Have you had a chance to look at that?
I have, Your Honor, there's no objection, but I'm not sure if that's an accurate amount. I think that victims relief, the victim specifically talks about the Victims Relief Fund. And so I think there may be another more amount. I don't know. Court wants to leave it open for 30 days so that the state can make sure that, or if you want to just do it today, I'm fine with that too.
Your Honor, I can inquire if there's additional. Part of that motion is from Idaho Crime Victims Compensation. I'm happy if the court is willing to give 30 days to just verify with Ms. Millhouse in our office if that's the final amount.
I think I'll do that. 'Cause I don't actually have the motion in my file. Is that recently filed or is that around? Oh, that is. I think I'll just leave it open for 30 days to just make sure the numbers are right.
You're
Even
done.
if there's an objection on that.
Thank you, Your Honor.
Pompa, you do have the right to make a statement. Is there anything you would like to say?
Honor, I just want to say that I do have remorse for what I did. I do wish that I could take back the actions that I had committed. I wasn't in the right state of mind. I was struggling both mentally, and me being on drugs didn't help my situation. And that's not an excuse for my behaviors, because I'm a firm believer that at the end of the day, people make their own decisions. And I just, looking back on it, I wish that I would have made some better decisions, because my grandmother only wanted the best for me, and she's supported me through a lot of my life, a lot of my childhood, when my parents have failed to do so. And I, at the end of the day, let her down. She put a lot of trust in me, just allowing me to even be in her house, be in her presence was sorry, was like beneficial, because I didn't have a lot of people out there in the community who were willing to support me. And I did go through the St. Anthony program. That was very beneficial for me. And I got out and had moved to Boise, and I was trying to in the living program, trying to find housing and working to better my life there and start my own life. And I failed to find housing towards the end of my stay at that program, and I did become homeless, which was when I started using drugs, and I lost my job. And after being arrested for absconding from juvenile probation, my grandmother was there to help me out. And I just feel that I've let down the community, and I've also let down my grandmother, and I'm sorry for that. And I accept the fact that there does need to be a punishment. I don't minimize my behaviors, and I do realize that what I've done is wrong. Thank you, Your Honor.
Thank you. As noted, factors I consider in a sentencing our protection of society, that certainly comes into play here. This was a very violent crime. We're just very fortunate that we don't have a fatality. Certainly, we came very close. I looked at deterrence, punishment, rehabilitation. I think all of those factors apply as well. I look at the prior record to see how that plays in. Certainly not the first criminal behavior, but not a lot of convictions as an adult. but certainly a turn of events that was very violent. It's also pretty clear that there are mental health issues involved. I take that into consideration. They certainly don't outweigh the need to protect society from the violent behavior, but that is a factor in sentencing. I think it was a factor the parties considered in drafting the plea agreement in this. So considering all of those things, I'm going to follow the plea agreement as the parties have entered into that. On count one, attempted murder in the first degree, the sentence will be 15 years, 10 years fixed, 5 years indeterminate. Count two, robbery, the sentence will be 30 years, 10 years fixed, 20 years indeterminate. I will run those sentences concurrent. You'll receive credit for time served on this. There'll be a fine of $1,000 on each felony. I'm going to leave, I guess, take under advisement the motion for restitution. Parties come to an agreement, maybe a stipulation with a proposed order on that. Or if we do need to resolve something, the state will have to set that up for hearing. Reimbursement of the public defender in the amount of $300, court costs and victims relief fund will be assessed at the standard amount. Any questions on any of that, Mr. Thomas?
No, Your Honor, thank you.
Bean?
No, Your Honor, I appreciate it.
Pompa, do you have any questions about the sentence today?
No, Your Honor.
You do have the right to appeal this decision. If you want to appeal, you should do that within 42 days. You have the right to an attorney on appeal, and if you cannot afford an attorney, one would be appointed for you. Any questions about your rights on appeal?
No, Your Honor.
If there's nothing else, we'll be in recess.